Can you please call the hearing number for the record?
This is hearing number 26 of Monday, 11th November, in the case of 0014 Holden Pierre, 0015 Atwan Ali, 0028 Allen Anista, 0053 Mivon Baron, and case 0055 Norris Jumeau.
Thank you. Can you please call the first witness?
Bernadin Renaud.
Thank you, Judge Renaud, for appearing before the Commission today and for escaping a meeting, I understand, to
yes,
get here.
That's right. Monday morning meeting.
Thank you. So the Commission requested that you appear as an expert witness in relation to a complaint received by Mr. Holden Pierre, in which he claims that he was denied a pension in relation to the time he served as a member of the National Assembly in the First Republic in 1970 and 1974 to 1977. He alleges that the Constitutional Post Special Pensions Act, Act 21 of 2014, assented by former President Michel in 2014, maliciously victimised people like himself because it set restrictions on the length of service of members of Parliament. The Act states that members should have, quote, served a minimum aggregate period of 48 months, close quote, to qualify for a pension. And he says this was done knowing full well that those serving in the First Republic would not qualify. And he claims this violates his constitutional rights. And so the Commission wanted to hear your views on this matter, given your expertise in the area of human rights and your leading role in the Constitutional Review of 1991-1992 that set the foundations for the Constitution of the Third Republic. So the floor is yours if you could help us. Thank you.
Thank you, Madam Chairperson. Good morning, commissioners and everybody present. Well, it's always my pleasure to assist the Commission wherever I can. Unfortunately, you mentioned a letter of 2nd of October. I was not in the country. I don't know what happened to it in the letter that you wrote me on the 9th. Otherwise, I would have been present, so okay. No problem. Yes, I escaped a meeting this morning to come to this one. Yeah, I got a letter about the case of Holden Pierre, and I studied it, and I have to clarify, I believe, procedures. I don't know the procedures here, whether it is time for me now to give an opinion. Because it seems that the case is not completed yet, is it? The hearing by the Mr. Holden Pierre, I understand, has been completed. But the other party, I don't know whether you heard the other party.
I mean, his case is ongoing, so we are still to hear from people in relation to his case. So the way, I mean, our procedures are generally, we get the complaint, we generally get a sworn statement. And from that sworn statement, we identify witnesses and suspects, and then we notify them, and then we call them, and then we continue. It's like a process, an ongoing process. So who were you concerned hadn't been heard?
No, because, you know, I thought I would have been more useful, maybe, after the case is heard by, from all the evidence is collected from all parties. That is, from the complainant and the state or whatever, the other side. And then once you are ready to consult and conclude, I would be more useful, I think, maybe at that stage. Because the line you sent me,
Yeah.
for me to give an opinion, normally I would like to have the statement of facts
Yeah.
so that I can base my opinion on. And not only for this case I'm talking about,
yeah.
generally, I don't know
Yeah.
what you think about that,
Yeah.
because I've listened to the case going on. I don't seem to hear the other party being answering. So I'm wondering whether they won't come up with the non-applicability or the non-applicable rule of natural justice. They have not been heard. I know some people came here, but I don't hear them saying, I'm testifying on behalf of the state or the government. They did not even come up with a certificate saying that the evidence I shall give is on behalf of the state. So,
I mean, in his case, we've had Pat LeBlash. I mean, people that we call from the government services. In his case, his land claim has been addressed by Pat LeBlash. This claim here hasn't been addressed by anybody, the constitutional claim.
the point I'm making, Mr. LeBlash came. He spoke as Mr. Pat LeBlash, but he did not speak on behalf of the state or the government. He did not even bring a paper saying the evidence I'm giving binds the government. So this is what I'm saying. On this one, maybe a suggestion is that the state answers, because it is a law is involved, policy is involved, and when I say the state, because the law was made by the National Assembly and approved by the president, so it becomes a law, which is the state answers for the law, if the law is not correct. Maybe not only in this case only, maybe for the other cases that I've heard, I'm always listening, when is the other party being heard? Yeah.
I'm not too clear here. For example, when Mr. Pat LeBlash came, he came as an officer of the public service answering questions on behalf of the Department of Lands that he works for.
I did not hear him say that.
Well, I think this was assumed because...
I mean, in
he
law you
came
can
with
assume. In the other, I mean, I'm saying this to help the
Yes,
commission, as I always do.
But he didn't come in his personal capacity.
No, he was calling, I mean, he said, I'm Pat LeBlash. You see, when I'm saying this, because at the end of the day, after you've done all this work, for another party to come or to take the matter to court for judicial review, because of the breach of natural justice, they say, oh, we're not heard, we're never invited. So this is the point I'm making before I start on this one. And for this one also, I was thinking, if I speak now, I am prejudicing the position of one of the party. I don't know whether you think the same as me. But if what you've heard, Mr. Pierre, if he's completed all his evidence, then you hear from the other one, the other side, which is the state. When you're deliberating, I think I can make more useful contribution at that stage in all the cases that you want me to come.
I mean, I understand what you're saying, you know, and I appreciate what you're saying. And I think from a fundamental fairness perspective, you're absolutely correct. You know, I do think, yes, we should hear from the lawmaker and get their story about this law and then look at. I think you're correct. You
because
know?
even me not to give a view and opinion, it is still on one side. I want to hear the other side also, whether there's any logic in what they are saying, any moral, because here it's not only for law, it's the justice and morality. I can come in at that stage in any of the cases you want me to come. Even now I'm here. If there's anything you will want me to assist in any of these cases, I can assist you.
I think you're right, and I think it's good to point that out to the Commission, because we have been making assumptions as we're going along, that we've called people that were working at SDH and people that have worked, and we have assumed that they are representing the government that they worked for, even though they might not have that capacity now that they had all the minister. So I think you are right.
But a way maybe to go about this is after, if you call the individual, not to throw away this evidence, when you compile the evidence, maybe at that stage you call formally on the other side to answer. Give them a chance to answer this. With this answer, you conclude your case for the other party, and then I can come in. come in. For example, for the SLA, licensing authority, I listened, but he did not say I'm testifying on behalf of the authority. Because I remember in court, we used to ask them for a document, bring a document that I'm testifying on behalf of government or authority or whatever, and the evidence I'm giving shall bind the authority because I've got the mandate. But now I don't know whether they can, I mean, the other side can escape, saying we were never heard. And this one, I'm ready to give my view, but when it comes to the conclusion, yeah.
I think that's really helpful. So thanks very much for that. I'm just sort of thinking now in my head whether we, next time we call Mr. Leblash, we clarify, you know, and the other people that we've called already that we have assumed are representing the government department they work for, then they would have to, I suppose, get instructions from the minister.
Yes, I think normally, for some of these cases, I'm listening the Attorney General, he represents the state, but I don't see his involvement at all in serving on behalf of the state. So I'm asked, this is just a thing for us to think about, whether at the end of the day, the state will find an excuse to say whenever involved the other party. But if after you summarize the facts, you can submit it at that stage to the state and see what they respond before we conclude, before I give an opinion.
I'm again trying to sort of get a clearer picture here. In the case of this law that came out about the pensions for the members of the National Assembly, now this was approved by a previous National Assembly.
Whatever it is.
Whenever it was.
Yeah.
Yes. Now, who do we
It's
call?
the state. It's
Who
a
do we
law.
call?
The
Yes.
AG's office answers for the state in perpetuity, always.
So we would have to call people from the AG's office?
The government, I mean, the state is represented in all matters before court or institution by the Attorney General.
Okay.
I mean, I'm trying to say this for them at the end of the day, nobody to escape saying we were never heard, rule of natural justice was never invoked, you see. And I think of because in court situation we do that. They have to be heard.
Well, just to clarify one issue, Mr. Renaud. Okay, you are totally right. In the case of writing to anybody in the government, let's say in any ministry, because usually they say address all correspondence to the principal secretary.
Yes.
So that means when we are writing to any person in that ministry or department, we have to address, inform the principal secretary.
Yes.
Okay.
And you can name also the person you want to,
exactly.
to come.
So it means it's officially the state.
This should be, this is a way I'm saying it.
Yeah, no, I'm trying to add that to that. Because they say all correspondence must be addressed to the principal secretary.
Yes.
Yeah, not to the minister, but to the principal secretary.
Well, I mean, this is the way I see it.
Yeah,
and if
thank
you
you.
miss it, the Attorney General is always there for the state, meaning the government and the state, and they can answer for this, I suppose.
Thank you. Okay.
Yeah. After that, whether public or in private session or whatever, when consulting, I am available, or anybody else can assist with the fair decision of the Commission.
So I'm thinking of all the detentions, you know, the detention orders. So we would have to call the Attorney General to come and tell us that there was a legitimate state of emergency that justified the implementation of that detention order. Otherwise, they haven't been heard, right?
Yeah, that's right.
Yeah.
I mean, after you conclude, you summarize, these are the facts, and you believe the state should answer this, because normally you can make a case, the complainant makes a case first before you call on the other party to respond. Some of the complainants come here, they'll just make statement and tell you stories and all this. But at the end of the day, after analyzing it, you find there's no case to call the other party to give an explanation. But whenever there are, you call them, and after that you conclude it, then you can get an opinion of any legal expert or any person to assist you. This is the way I'm saying it, so that we move on in a proper manner. But for the evidence collected, they are useful still, because you use it to prepare the case for the complainant to get the respondent to respond to that.
I think the Attorney General's going to have a lot of work having his way.
Well, this is one of the things that I don't know whether everybody is thinking about the cost or the process of the democratic process. It's a different thing from previously, where you sit down. Now you have to answer so many things, so many things. And I know of things that I've just learned the way it moves in the government. You have to change all these things, completely change. Because you have to answer, you have to say things which is different from what the public servant used to say in the past. And maybe we have to retrain our civil servant to rethink according to the new democratic process.
So you came for one thing, but you've been extremely helpful on another.
Yeah, because this is that I'm here to assist, to help the process of democratization, the process of hearing and sorting out things and all these things. Yes. And I don't want at the end of the day you've worked for a year or two and then somebody just come up and say, if you go to court on point of law, maybe they will win, huh? If you have not called them.
Any other top tips?
Well, if you think of anything, I'm there always, you call me. I'm thinking of this one, that process of collecting information and evidence. But I don't know. If any other thing comes up, you let me know. I'll come. Anything?
Yeah, thank you so much for highlighting that.
Thank you, Chair. Thank you,
yeah, it's really, really useful. And so the Attorney General can expect to receive a lot of correspondence from the Commission, because we are at the stage in some cases where we want to be able to make, we've collected all the evidence, so we can go to him.
Whoever is the other side must respond first,
Mm-hmm.
and then you can invite me, I can come, or anybody else for that matter, because
Yeah.
the law provides that you can seek expert assistance.
Yeah, exactly.
No need to be an evidence again.
Yeah.
I'll tell a suggestion again for the expert witness, because at the moment you have only the complainant coming in. Complainant call people, and then you summon people to fortify the case of the complainants, the Patla Blast, the Mr. who and so on and so forth, to clarify the case of the complainants. But then you have the other side has to give you information or whatever. But for the expert, for example, I come here, I don't represent either party. Under the law, I want to assist the Commission. Maybe no need to come here, take oath and give evidence, because we give views and opinions. But if you take oath to give evidence a statement of facts, which I have seen, heard, or some otherwise I've come to know about it legally. And another suggestion to think about for the others to help you. It is something that you can get more help if it is not evidence assessed, because we give opinions, it's not evidence. I've heard Mr. George came and give a lot of, I'm sure a lot of us can come and assist you.
Well, we will definitely be calling on you. So thank you so much for coming and highlighting that for us, because I do think it's something we've sort of overlooked in a way going along, right? We've made assumptions,
yes,
we haven't been clear.
Sure.
So it's great that you've pointed this out to us now, so we can go back on what we've done and then find those places where we are ready to get a response.
Thank you very much. Thank you very much.
Yeah,
and,
you've made my day. Thank you.
Okay.
Thanks very much. We do have lots. I think we can adjourn now because our next witness isn't due until 11 a.m. So, no, we'll adjourn now and we will resume at 11 a.m. Thank you.